Now let's turn to jurisdiction. I mentioned earlier that you could file a 12B motion for lack of jurisdiction. Well, what does that mean? Well, for a federal court to hear a case, that federal court has to have both subject matter jurisdiction and personal jurisdiction. So let's look at subject matter jurisdiction first. This is a constitutional requirement under Article 3 of the Constitution, and it's based on the idea that federal courts are courts of limited subject matter jurisdiction. Why? Because the federal government is a government of limited powers. It's only the powers that are enumerated in the Constitution that the federal government can wield. If it's not specifically enumerated in the Constitution, then it's for the states. So because federal courts only can do limited numbers of cases, you have to show in your complaint as the plaintiff why this case should be in federal court. And really, there are only two ways you can get into federal court on subject matter jurisdiction, what's called diversity jurisdiction or federal question jurisdiction. Diversity jurisdiction means that the parties are from two different states. They're either citizens of different states within the United States, or one is a citizen of a foreign country, and the amount in controversy has to be over $75,000. So not minor cases, they have to be major cases involving citizens of two different states. That can get into federal court. Why? Because particularly in the early days of the Republic, and probably even now, there is concern that if you've got parties from two different states and the case is brought in the state courts of one of those states, that maybe the state judges or the state juries will be biased and we'd be better off going into a federal court. Now, of course, the federal court still sits in that state, so it's not as if it's a wholly different group of people, but federal judges have lifetime tenure, they can't be fired, they're perhaps more insulated from political pressures, and so the thought is that by allowing federal courts to hear those cases, we limit concerns about hometown bias. So that's diversity jurisdiction. Federal question jurisdiction means that the case somehow arises under a federal statute or a federal constitutional provision. So if you are claiming that a state statute, for instance, violates the federal constitution, that would arise under the federal Constitution. If you're bringing a case under federal environmental protection laws, that arises under the federal statute and so forth. So federal question cases are cases that arise under federal law. Now, state courts, just like state governments generally, have more general jurisdiction. As long as it's not given to the federal courts, it can be heard in state courts. And even if it is given to federal courts under either of those two bases of subject matter jurisdiction, it can also be brought in a state court. So if you have a constitutional claim that you want to bring under the US Constitution, you don't actually have to bring it into a federal court. You could bring it into a state court. There are only a very limited number of cases that by statute are required to be brought into federal court. Almost anything can be brought into a state court. So that's subject matter jurisdiction. Turning now to personal jurisdiction. So let's say you figured out that you have a case that could get into federal court. The next question is, in what state do you bring it, right? Because there are federal courts in every state of the union. So in what state can you bring that particular case? If I have a dispute and I'm in, let's say, Maryland and you're in New York, can I bring that case in Alaska in a federal court? Probably not. Why not? Well, there's this idea of personal jurisdiction, and here, this is also a constitutional requirement. It's a 14th Amendment due process right. And the idea here is that there needs to be some nexus between the place you bring the suit and where some aspect of the case took place. Now, originally, the US Supreme Court in 1877, in a case called Pennoyer versus Neff, held that the defendant has to be physically present in the state or have some property in the state, and then you could bring the lawsuit there. And so it could be a residence, what's known as a domicile, or if it were a corporation, the place where the corporation is incorporated, or something like that. Now, the problem is that that sort of territorial physical nexus is okay for certain kinds of cases, but it doesn't work in a world where we have communications technologies, transportation technologies that go long beyond borders that are territorially defined. And it doesn't really work when we're talking about national and multinational corporations, because things can happen in one place that have a very, very harmful effect somewhere else. And we don't necessarily want to force the plaintiff to have to go all the way to where the defendant happens to be in order to file the suit. We might want to allow the plaintiff to sue closer to home. And so in 1945, the Supreme Court decided another case, International Shoe versus Washington. This is one of those rare cases I mentioned earlier where the Supreme Court actually overruled aspects of Pennoyer versus Neff, and they said as long as the defendant has sufficient minimum contacts or relationships with a state such that it is fair for a state to assert jurisdiction, then it's permissible. Now, what counts as minimum contacts? That's very confusing, and it is the source of many, many cases since International Shoe. How many contacts do you need to have? How many contacts are sufficient? What sorts of contacts are allowed, and so forth. We're not going to get into all of those details for the purposes of this introductory business law course. The key point is that you need to know that personal jurisdiction is based on contacts with the state, that it is constitutionally mandated as a due process requirement, and that it is at least somewhat limited. In other words, the plaintiff cannot simply choose any state in the country. The plaintiff needs to choose a state where the defendant has some sort of contact with that state. And states have passed what are called long-arm statutes that say, here are the sorts of out-of-state defendants we want jurisdiction over, and you would have to look at, is this the kind of defendant the state wants jurisdiction over? And then assuming the answer is yes, can the jurisdiction be asserted under the Due Process Clause of the U.S. Constitution, or is there no personal jurisdiction in this particular case? Now, personal jurisdiction, because it's an individual due process right, can also be waived. And so if the defendant simply shows up in a court and says, okay, I'm here, I'm happy to litigate this case, then we're done and personal jurisdiction is no longer an issue. Now, subject matter jurisdiction and personal jurisdiction are both constitutional requirements. But there's also venue. Venue is a matter of statute. There's a federal venue statute. Every state has venue statutes. And here the idea is, okay, you can bring this case in a particular state, but maybe there are 4 district courts within that state. How do you decide where within the state? Or you might say, okay, there will be personal jurisdiction in 4 different states, and so you could file it in any one of those 4 states. Might the venue statutes then tell you that the judge might allocate those cases to one of those states, one of those venues over another? And so we would follow those venue statutes after we figured out, do we have subject matter jurisdiction, and therefore we can be in federal court? Do we have personal jurisdiction? Now we know which set of federal courts are potential, and then we would apply the venue statute, and a judge would have some discretion to move the case within a particular legal system to where it makes the most sense.